Yield the floor to MP Perkins for 6 minutes.
And welcome back. Commissioner, I'd like to talk a bit about the Auditor General's report, which you said you had reviewed as part of this. And the Auditor General found that Ms. Fischerin not only held the conflicts of interest you referred to in your opening statement, but mismanaged and had a conflict in interest in a number of other transactions. Does your report cover that when Ms. Fischerin mishandled a conflict when she granted Universal Matter, Inc. a payment of $225,000 on March 9th, 2021?
First of all, mismanagement is not part of my remit. So I'm looking only at conflict of interest. We actually looked at every single decision that Mrs. Fischerin took. My colleague Michael can give you details.
Yeah, so beginning at paragraph 61 of the report and going all the way to about paragraph 74, we've lumped together all of the different instances of votes or decisions that were taken. So in certain instances, Ms. Fischerin had declared conflicts of interest but had abstained instead of recusing. In other instances, she had declared conflicts but voted outright. Another, she failed to declare a conflict and had voted. And then also the COVID relief payments where she relied on internal advice.
So she didn't breach it twice, as your report said. She breached it multiple times based on that. Can you tell me how many times she breached it?
In total, there were 24 instances.
24 times as chair she breached the Conflict of Interest Act.
Yes.
So, and your report deals with just the NR store and the Mars and the Fischerin Vanity Center that she set up and their roles. That's in it. So when you looked at it, did you look at any other governor and council besides Mr. Ouimet? I do have some questions about Mr. Ouimet's in your report, but did you look at any of the other GICs? Because the Auditor General also named considerable number of other GICs who had conflict of interest.
We start an investigation and look when we have reason to believe there's grounds for an investigation or when we're being asked for. In this case, we were specifically asked for by Mr. Ouimet to look after Mrs. Fischerin and Mr. Ouimet, and we did so.
Do you not have the power to investigate anyone you want? You don't have to wait for a parliamentarian to ask. You can, when you are made aware of conflicts of interest in your mandate, can you not go at that? When you see that the Auditor General has named other governor and councils, why didn't you expand your report? 82% of the transactions that the Auditor General looked at, she found directors were in a conflict of interest. That's not a mistake of a legal advice. That's a culture of conflict of interest.
Yeah, but you forget, I can, as you quite rightly saying, self-initiate, but I have to initiate it if I have reasonable grounds to do so. The Auditor General report came after we issued the report on Mrs. Or just shortly before we issued. Was it before or after? No, who came first?
The Auditor General's report came first, yeah.
And we came about a month after.
So are you going to initiate, now that you're aware of way more instances of conflict of interest on your own?
What purpose would it serve? My job is...
Well, I'll tell you what, since you asked me the question.
Let me finish my answer. I can, if I make it, what can I do? I can expose. That's all I can do. I can't fine, I can't fire.
With respect, Mr. Commissioner, that's your job, is to expose conflicts of interest. And the Auditor General found 82% of the time. You dismissed Mr. Ouimet and you said it was de minimis. It is inappropriate for somebody who's a public office holder to personally benefit. And in the case that you outlined, they personally benefit because that loan or that grant from the board that he was on that he voted for benefits that company. Not only did he do that, Mr. Ouimet, but he actually has numerous other conflicts of interest exposed by the Auditor General. So I ask again, since your report doesn't deal with the governor and council's overall and the culture of conflict of interest, will you take a look at all those other instances, including Mr. Ouimet?
And as I've answered you before, what purpose would it serve? All these persons...
Then what purpose do you have a job if you're saying that you don't have any responsibility whatsoever to look at conflicts of interest?
No, I
Just
do.
because, isn't that what you do? You expose them and let the public and parliamentarians decide what should happen since there is no sanctions. So why is it that you dismissed Mr. Ouimet when he had lithium Nouveau, and Swirl Tech, all his conflicts where he voted millions and millions of dollars to companies that he had investments in. Your report is inadequate, and you should initiate conflict of interest investigations where governor and council have been abusing their position 82% of the time.
Let's start at the beginning. My job is there to expose conflicts of interest. But if I find them and I expose them, then the person has to answer to the public, to the Prime Minister, or to the Speaker of the House, as the case may be. And my job is done basically in exposing it. I can't fine, I can't...
Yes, that's true, but you're not exposing them.
But they have to be in office. When they are no longer in office, what good does it serve to
So
expose?
your excuse is it's okay for a conflict of interest and you don't have to look at abuse of taxpayer dollars as long as they're no longer in office?
Abuse of taxpayer dollars is the Auditor General's job, not mine. Mine is conflict of interest, pure and simple. And there is no conflict if you're no longer in office. You do not have a conflict anymore.
So if I commit a conflict of interest while in office and I don't get caught, it's no longer a conflict of interest?
Of course, it was a conflict of interest. If I wanted to, I can. You're out of office. I start an investigation. I say, while you were in office, you had a conflict of interest. End of story.
Thank you very much, Commissioner. I'll now yield the floor to MP Van Buynen.
Thank you, Mr. Chair. Can you hear me? Is my mic on? Yep. Okay. Good. You appeared over the summer for the Public Accounts Committee on the topic of the AG's report on STDC. I'd like to ask you some questions about some of your testimony. For clarity, you found that Mrs. Verschieren was in breach of the Act given that she'd failed to recuse herself while participating in decisions where a conflict of interest existed. Is that correct? And that is the crux of the issue, is it not?
Yes, the Act calls for recusing. It does not have a provision of abstaining at all. However, in a couple of cases when there was, she declared her conflict, and then there was what they call the non-controversial motion at the beginning, the consent agenda. Mm-hmm. And she voted on those because she had already declared that she couldn't do. She should have abstained. She should have actually left the room. The moment she said a conflict of interest, should leave the room and not participate. That's what the Act demands. She didn't. She abstained first, said I haven't, and then she actually voted on, in some cases, in other cases she didn't. What she should have done is leave the room, right? And with the emergency, it's the same thing. She was told on wrongful legal advice, there is no conflict here, so she voted.
Okay. Thank you. I'm having trouble with my earphone. Okay, so by failing to recuse herself, she also breached the STDC's own conflict of interest policy. Is that correct?
Correct.
Okay, and there is no record of her ever leaving the room on any of those votes?
No.
So I'd heard that in earlier conversation that individuals had claimed to have left the room, but it didn't reflect it in the minutes. So is there an obligation on whoever was the chair or whoever was the secretary for that meeting to reflect who was in the room and who wasn't in the room?
Michael, why don't you answer that?
Yeah, so the minutes in certain cases reflected that individuals had left the room, and in certain cases they had not. So one of the, I guess, objectives of our examination was to determine whether or not they had in fact left the room and the instances where they had not. So in certain cases, there was a discrepancy between the minutes and what we had heard from witnesses, but in most cases, the minutes were consistent with what had happened.
Okay, good. So I'm sure that there are people in this room here that you as a commissioner, as an appointment by the Prime Minister, failed on your job by not sufficiently keeping an eye on Mrs. Verschueren throughout her appointment. How do you respond to that?
First of all, she was a public office holder. She's not a reporting public office holder. So all she has to comply with the Act. It is not like reporting public office holder who, when appointed, has to fill out a long, detailed questionnaire, and then we go with the person through it and say whether there are conflicts, whether she has to understand. And then there's an ongoing dialogue between that person and us, and each year, at the end of the year, we review everything, make sure that things will. A public office holder like Madame Verschuren, etc., has only an obligation to comply with our act and to comply with the internal regulation, in this case STDC. But there's no ongoing dialogue as she comes to us if she wants to. Otherwise, we don't monitor. We have nothing to do with her. The act is there, and it's up to her to comply with it.
It's the integrity of the individual.
That's it.
That is
Correct.
that's the driving issue. Okay, thank you. That's all my questions, Mr. Chair.
Merci beaucoup. Je passerai maintenant la parole à Monsieur Garon pour...
Mr. Garon, the floor is yours for 6 minutes. Thank you, Mr. Chairperson. Gentlemen, thanks for being here. Commissioner, welcome. Thanks for being with us today. I think that the work that we do in this committee, regardless of our political affiliations, is important. I take it seriously, and I think that all parliamentarians here also take that work seriously. And what I find particularly upsetting and disturbing is when witnesses appear before us who don't take our work seriously. And I'm not referring to you, mind that, if that can be of any relief to you, but I read your report, I listened to your testimony, and I'd like to read out 2 quotes from Ms. Verschuren here before this committee where witnesses are supposed to tell the truth. And I quote, "In all cases where I disclosed a perceived conflict of interest, I withdrew from the board meeting and I came back after the decisions were taken and recommendations were issued to the board. The same applied to all board members." And I continue, verbatim quote from this meeting, "When the board recommended that the projects be accepted, I left, other members left, and I waited until I was called back in when the recommendation was issued. I was unaware of, etc., etc., etc." So you can see where I'm going with this. Now, I'd like to come back to the testimony before this committee by that individual. I read your report. I've listened to your testimony. Someone is lying. Someone has lied to the committee. Is it you or is it Ms. Verschuren who's lied? Response. Well, there are 2 sources of evidence: Ms. Verschuren's testimony and the reports, i.e. the agenda of each meeting. Now, my counterparts and colleagues reviewed all of the agendas, and in most cases she did not recuse herself, only in a small number of cases. I don't know whether Ms. Verschuren's memory is failing her, but there's a discrepancy between what she's told us and what we find in the meeting minutes. I understand, sir. Especially when it comes to COVID relief payments, she did not recuse herself. That much we know. Would you like to chime in? Well, yes, I don't want to come to her rescue per se, but what the Commissioner's report has shown is that in most cases where there was funding, seed funding or start-up funding, well, indeed, Ms. Verschuren did recuse herself. I'm sorry to cut you off. You know how valuable our time is in committee proceedings like this today. But in your report, you noted that there were 24 violations of the Conflict of Interest Act. You've determined that Ms. Verschuren appeared before the committee, and to her mind, there's been no single violation of the Conflict of Interest Act. Sometimes we lose our memory, sometimes we forget things, but 24 times? That strikes me as systematic before a parliamentary committee where the onus is on you to tell the truth. I'm asking your opinion. This is what's supposed to be a normal state of affairs. Can you be mistaken 24 times in an appearance before a committee? Well, I think you need to ask that of Ms. Verschuren herself. All I can tell you is what we've done. We in fact, interviewed her, and we looked at the documents and reviewed them. Question. I'd like to come back to the ministers and the department's role. Now, having listened to the current minister and the previous minister, the rhetoric goes like this. This was public funding, and that organisation was not directly under the aegis of the department. There's a board of directors, and we're not responsible. And when the Auditor General signalled that there was wrongdoing, we froze the funding. That's the kind of rhetoric we're hearing. And yet, it strikes me that when it comes to the legislation itself, the previous minister, i.e. the current government, could have initiated audits and conducted verifications and ensure that that public money was being managed in compliance with the Conflict of Interest Act. Don't you think that that would have been normal? Don't you think that the government's investigation, and I'm not criticising you per se, but don't you think that this investigatory work took far too long to get started? And don't you think that this demonstrates that the department has a number of shortcomings and that it should have launched this investigation? This brings to me an even more straightforward question. Is there perhaps a smoking gun here? Well, you're asking me about the department itself, but it doesn't fall under my remit directly. You're talking about political decisions, and it's the voters that are the judge and jury. Well, let me reformulate my question. You produced a report. The Auditor General did her job, and there were assessments that were undertaken. Now, is it your opinion that the department could have carried out some of these verifications ahead of time, and you could have therefore prevented the misuse of public funds, wrongdoing and misconduct? Well, STDC was founded. There are a number of individuals who were appointed. There was a terms of reference that were set out, and I can't think of the word in French. And of course, we wanted to bring on board people with a level of expertise, and that is why we didn't appoint them as public office holders per se. In other words, they had no direct contact with us, no obligation to disclose their financial position. And that was a decision that the government made. You can relitigate that decision, but it amounts to that. Now, why was there no anything further done when it came to the appointments? When there were appointments suggested, I just had to follow the rules. Thank you very much, Mr. Gall. Mr. Massey, 6 minutes. The floor is yours.
Chair, and I guess the first thing I want to go to is on November 17th, 2023, a news report revealed that you were investigating Mrs. Verscharen, the conflict of interest, and then on November 20th, she resigns. So when did you actually officially begin your investigation on Ms. Verscharen?
So we received the complaint on November the 10th.
Okay.
And let's see, we wrote on November 16th to launch.
Okay. So would Ms. Verscharen know about that? Was she notified that she's in an investigation? And
Yeah, the process is we write to her, we say we're starting an investigation, and we would like, and we point out we want to interview her, and here's issues in what we want to discuss with her.
right, so that would have been done shortly after November 10th or November 16th. Would that have been the?
Yeah.
So basically, she gets the letter, then she resigns. That's, you know, so yeah.
Well,
Does that happen often? That you actually write to somebody and say, we're going to actually investigate you, and then within a matter of hours, they resign from their position?
I've only been in the position 1 year, so I can't tell you, but maybe my colleague has a better memory.
Yeah.
I mean, to my knowledge, I don't think it's it has happened in the past, but I don't know what would have precipitated resignation in this case either.
No, and I'm not asking for that. I just think, though, that, I mean, I haven't seen such a rapid response to something like that in my past. It could be wrong, and I mean, I could easily go find out, I guess, if we looked at detailed information of other cases. I guess the one of the things I'm concerned about is that she declined. Let's go through the things that she did. She declined the conflict advice. She didn't leave the room, and a whole series of different things. But of all those things in the boardroom at that point in time, was there any consequence when in SDTC for her or for colleagues that knowingly saw this behavior and said nothing? Is there any actual consequence to those board members and or for herself, the failure of actually reporting or pointing that out? Because, you know, there can be willful consent by people just not saying anything. I've been in lots of rooms where people know people have either said or have done or acted the wrong way, and people have just let that pass and go by because it could be over an issue of sexism, racism, inappropriate behavior. It could be, in this case, voting. But what were the consequences on the board members for the system set up in place?
The way the system works is, in effect, when there is a violation and we are made aware of it, or we investigate our own, then we can expose it and we make it public. That is the penalty. That your reputation essentially is damaged by the report that shows that you have done that. In terms of the interaction in between the board, etc., all we have is a record of what happened and the testimony of the people whom we interviewed. And so I can't answer your question. I don't know whether there was willful looking away, as you suggest, or whether there was benign ignorance or what.
Okay. So, I mean, this is where some of the concern for accountability that I've had about this file is because this was set up over 20 years ago, and it's lived through a number of ministers that have left here in disgrace, including Minister Bernier and Mr. Clement and others, and we still have a system in place, potentially, that allows for this type of conduct and behavior consistently and an openness there. And I think I would agree that we still would want to shed the light on the truth. And the reason, I guess, to answer your question that went to Mr. Perkins, is I believe that it needs to be followed through is because how do we then actually show the public the actual full damage that this malfeasance takes place from these corporate boards and agencies that are set up arm's length distance, often on purpose. And I wanted to point out that the staff are fully funded by federal taxpayers, but they didn't enjoy the same privileges of protection for whistleblowing, nor benefits, nor union, and nor so forth in terms of the workplace. How do we actually, you know, dispense from everything when we don't know the full damage of what took place from the actions of this board?
When you say the full damage, to the extent there was damage, you have the public, you have the report of the Auditor General. If I would investigate these people, all I could prove that they had, assuming you're correct, on various occasions violated the Conflict of Interest Act. What would that add in terms of the public knows right now the report is out. It's a very damaging report. The whole board resigned. As you know, it's been moved to the NRC, etc. There have been consequences. I don't feel there would be anything added by my going over past activities of people who have resigned, who are no longer in that position, said while you had that position, you misused it.
Sure. I guess from my perspective, from lay people, is that there's more than just the exposure here of an individual and her behavior that have, obviously you've ruled on, and then the others that were around her. It's maybe a structural problem with some of these boards and operations, and I think a full continued thorough examination of this situation should expose some of that, because I'm willing to bet this isn't the only situation where we see malfeasance and irregularities and boardroom minutes that aren't completed or not reflective and when it deals with taxpayers' money. I would prefer to see this finished for those reasons, Mr. Chair.